We have Nicole Aaron.
Nicole Aaron on page 1. Yeah.
Working here, we have Nicole Aaron, our case 2021 CF-262, in Sarah contract police approval not guilty and guilty count 1, attempted robbery, misdemeanor snatching, and burglary following. With good disposition, should be sentenced to 4 months in the Duval County Jail, should be awarded all credit for the initiative service of bar, and for costs of the prosecution. And Judge, this is also a plea as should be considered best interest to do so. I did not have anything that indicate that specifically.
All right, that's fine. Is this the state's recommendation in this case?
Yes, Your Honor.
Acceptable to the victim
Yes, sir.
and it's within the guidelines?
It is, Your Honor.
She's not entitled to a PSI.
No, sir.
Ms. Aaron, raise your right hand. You solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
Okay, put your hand down. Your name is Nicole Aaron.
Yes, sir.
I've heard what your attorney just said, that you wish to plead guilty to the third-degree felony of attempted robbery by sudden snatching. You could have received up to 5 years in prison for that. Is that what you wish to do, is plead guilty to that charge?
Yes, sir.
Have you had enough time to speak to your attorney about what you're doing today?
Yes, sir.
Satisfied with his advice and representation?
Yes, sir.
You under the influence of anything this morning?
Sir?
Are you under the influence of anything this morning? Any drugs or alcohol?
No, sir.
Has anybody threatened you to get you to plead guilty?
No, sir.
You're pleading guilty because you believe it's in your best interest to do that.
Yes, sir.
You understand if you plead not guilty and have a jury trial, you're giving up that right.
Yes, sir.
Party stipulated to a factual basis.
The state will stipulate, Your Honor.
Court finds a factual basis exists for the entry of the plea. Any DNA evidence known to exist that would exonerate the defendant.
There is none known to the state.
And there's defense.
Ms. Aaron, you understand if you were not a citizen of the United States, the entry of the plea could subject you to deportation.
Yes, sir.
And you understand if this were a sexually motivated offense, or if you've been convicted of one before, that the entry of the plea could subject you to a civil commitment.
Yes, sir.
Ms. Aaron, Mr. Beard went over with you a form, I'm holding a copy of, I know you can't read it, plea of guilty and negotiated sentence. He went over that form with you?
Yes, sir.
Did you understand everything on the form as he explained it to you?
Yes, sir.
Any questions about anything that's on the form,
No, sir.
or anything that's happening here today?
No, sir.
Court finds that Ms. Aaron has freely, knowingly, and voluntarily entered with full understanding of the nature and consequences of the plea. Therefore, the court accepts her plea of guilty to the third-degree felony of attempted robbery by sudden snatching. Adjudicates you guilty of that offense, sends you to 4 months in the Duval County Jail with credit for
103 days.
103 days times 30. You'll pay $518 in court costs and $150 public defender fee and $100 cost of prosecution fee. Anything else from the state?
No, sir.
Defense?
There.
Ms. Aaron, you have 30 days to appeal this sentence if you believe it to be unlawful. If you cannot afford an attorney, one will be appointed for you. Thank you, ma'am. That will conclude the hearing in this case.
too. Where they at? They're already on? Yes, sir. Thank you. He put them both on the table. What? But right now, I'm getting worried about audio. You can get it at 10.
We're not on the record yet. We have any preliminary matters. You need, why don't we, let's go ahead and go on the record while Mike and these guys are figuring it out. So, are you ready? All right, let's go on the record, show Mr. Tillis is present with his attorneys and the state,
Judge, Mr. Tillis informed me at the end of the day yesterday and again this morning that he would like to present an oral Nelson motion this morning.
Okay, Mr. Tillis, you can stay seated, but raise your right hand. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir, I do.
All right, put your hand down, what side of your mouth, sir?
Can the reporter hear me clearly?
Mr. Tillis, I'll let you up there, just tell me what's on your mind.
Well, the mask is the reason I asked, Your Honor. Okay, I have a couple of matters that I would like to address concerning Mr. Fletcher's representation. The first matter involves witness Cliff. and how Mr. Fletcher's refusal to investigate and examine the witness has severely prejudiced my defense. And the facts are, Mrs. Gunter was seen alive in Louisiana on April the 9th, 2015. Ms. Gunter met her death sometime between April 9th and May 28, 2015, the day of my arrest. It has been alleged by the state that I held Mrs. Gunter captive in a soundproof room for an undisclosed amount of days, during which time I allegedly forced her to have sex with several other men. On April the 30th, 2020, I complained to the court that Mr. Fletcher would not examine my defense witnesses. The court subsequently advised Mr. Fletcher to examine the defense witnesses. 5 months later, in response to the court's advisement, Mr. Fletcher arrived at the jail and consulted with me on November 21st, 2020. I gave Mr. Fletcher a list of 23 defense witnesses that were listed in the April 30th complaint, whereupon Cliff's name did appear. That list has been entered into the record through the clerk of court. Cliff was staying inside my home off and on during the months of April and May 2015. That is during the window of time that Ms. Gunter met her death. Cliff was inside my home when I was arrested on May 28th. After I was arrested, he remained in my home alone for an undisclosed amount of time. Mr. Fletcher has repeatedly refused to locate and examine Cliff. Mr. Fletcher contends he will use witness Dale Beam in Cliff's stead. Dale Beam has never stayed or lived inside my home. Beam was not inside my home during my arrest, and he does not have the personal knowledge about the inside of my house equal to Cliff's knowledge of the house. Additionally, Beam resides in Louisiana. If in fact he testifies during the trial, he would have to testify Zoom. Where Cliff, he resides in Duval County and could testify in person, and he would have more knowledge to offer the jury. Cliff's testimonial evidence could establish Mrs. Gunter was not being held in a soundproof room inside my home, because Cliff has knowledge there was no soundproof room. And Ms. Gunter was not inside my home at no time during the months of April and May. Cliff's eyewitness to the matter makes Cliff a material witness that validates my assertion that alleged the confession regarding the soundproof room and Mrs. Gunter's presence inside my home was a bogus confession. That's the first issue. The second issue, it involves witness Snyder in Henwood, and how Mr. Fletcher's refusal to investigate and examine these witnesses prejudiced my defense.
I'll tell you what I want to do, Mr. Tillis, and I don't mean to cut you off. You're obviously reading, and that's fine. What I would suggest we do, since you're doing that, is that we make your document a written Nelson petition, make it a part of the court record, give me a chance to review it this morning, and then I'll ask Mr. Fletcher for his response, and we'll go from there. Obviously, I have no idea how I rule on it.
Well,
But we've got a jury waiting, we've got, it looks like a number of pages there, and we're just not gonna sit here while you read.
well, the jury waiting, Your Honor, the jury can wait. The law states that the
Mr.
Nelson
Tillis, what we're
petition...
gonna do right now is you're gonna be quiet, because that's my ruling. You've got those papers, I'm happy to have those, admitted as a written Nelson petition, and I will review them this morning, and then that's how we will proceed. So if you will hand those to, if you don't wanna file it, that's fine, but that'll be the end of it. But you can hand those to one of the bailiffs, and they'll give them to Madam Clerk.
I would request the court copy them immediately and pass me a copy back.
All right, we'll make sure we get a copy of it.
And I would also like to place on the record that Torres versus States, the court is not following the procedure mandated for Nelson petitions.
All right, Mr. Tillis, hand those to the
Yes.
bailiff. We'll make sure we have a copy of those, and we'll handle that matter a little bit later this morning after the court had a chance to review.
Excuse me?
No, sir,
There's
Mr.
one more
Tillis,
issue.
you need to be quiet now. Mr. Fletcher, any other preliminary matters we need to address?
No, sir.
Mr. Bryant, on behalf of the state.
Yes, Your Honor, the state has submitted an evidence list. I gave a courtesy copy to Your Honor.
I have it.
I've given copies of the evidence to Mr. Fletcher and Mr. Metters as well. I have a notebook prepared with it all pre-marked.
Hold on one second. Ken, go ahead. You don't have to accept.
I mistakenly gave her a piece of paper that didn't belong in there, Your Honor. The last piece of paper.
All right, give this back to Mr. Tillis, and then give it back to Madam Clerk, and Madam Clerk, at some point this morning, have somebody make a copy of it.
Thank you.
And give me the copy. All right, Mr. Bryant, go ahead.
So we have those documents. I have included within the evidence, Your Honor, copies of the transcript, which should be marked as a court exhibit only, because those do not go back to the jury. So everything else is marked and labeled. For the record, it's going to be states A as an apple through states 5K, no, excuse me, 5I. In the evidence list, 5J and 5K, the state is not submitting for introduction of that evidence yet. I have it pre-marked, but I have not submitted it. So it's through 5I, which would be states 113.
Okay, anything else from the state?
No, Your Honor.
Mr. Fletcher, anything else?
No, Your Honor.
Okay, and I'll remind the attorneys, as much as possible, certainly during opening and direct and cross, you have to be at the podium. And anytime you want to interpose an objection or address the court, make sure you're speaking into the microphone so we can pick that up. Okay, anything else before we proceed?
No, Your Honor.
No, Your Honor.
Jury?
We're ready for the jury.
All right, let's bring it in.
Test.
And Judge, we would invoke the rule.
All right, the rule has been invoked. I'll expect both parties to inform their respective witnesses of the indication of the rule.
Yes, sir.
For the record, it is a long walk from the jury room since we're utilizing 402, courtroom 402 as our jury room. Which, for the record, has been properly prepared, all books removed, and cameras turned off. Members of the jury, go ahead and take your seats whenever you come into the courtroom. You can take your seats. Everyone will remain standing as a show of respect until you're all seated. So just go ahead and take your seats whenever you come in. Thank you. Everyone may be seated. Good morning, everyone. Our case set for trial today is the state of Florida versus Russell Tillis. Is the state ready to proceed?
Case ready, Your Honor.
Defense ready to proceed?
Yes, Your Honor.
Madam Clerk, if you would swear in our jury.
Please rise and raise your right hand. Do each of you solemnly swear or affirm that you will well and truly try the issues between the state of Florida and the defendant and render a true verdict according to the law and the evidence, so help you God?
Thank you. You may be seated. And members of the jury, good morning. Welcome back. Thank you for being prompt this morning. You have been selected and now sworn as the jury to try the case of the state of Florida versus Russell Tillis. This is a criminal case. The defendant is charged with murder in the first degree, kidnapping, human trafficking, and abuse of a dead human body. The definition of the elements of those crimes will be explained to you later. It is your solemn responsibility to determine if the state has proved its accusations beyond a reasonable doubt against the defendant. Your verdict must be based solely on the evidence, or the lack of evidence, and the law. The indictment that I read to you yesterday, or on Monday, and yesterday, is not to be considered by you as any proof of guilt. It is my job to decide which laws apply to this case and to explain those laws to you. It is your job to decide what the facts of the case may be and to apply the law to those facts. Thus, my job and your job are well defined, and they do not overlap. And this is one of the fundamental principles of our system of justice. Before proceeding further, I think it will be helpful if I explain the basic outline of how the trial will be conducted over the next few days. At the beginning of the trial, shortly, the attorneys will have an opportunity, if they wish, to make an opening statement. The opening statement gives the attorneys a chance to tell you what evidence they believe will be presented during the trial. What the attorneys say is not evidence, and you're not to consider it as such. Following the opening statements, witnesses will be called to testify on their oath. They'll be examined and cross-examined by the attorney. Documents and other exhibits may also be produced as evidence. After the evidence has been presented, the attorneys will have an opportunity to make their final arguments to you. Following those arguments by the attorneys, I will instruct you on the law applicable to this case. And after the instructions are given, you'll then retire to consider your verdict. You should not form any definite or fixed opinion on the merits of this case until you've heard all the evidence, the argument of the attorneys, and the instructions on the law by me. Until that time, do not discuss the case among yourselves. And I now instruct you not to communicate with anyone, including your fellow jurors, about this case. No communication includes no emailing, text messaging, tweeting, blogging, or any other form of communication. Do not send or receive messages to or from anyone about this case or your jury service. If you become aware of any violation of this rule or any other rule that I give you in this case, you must let me know by telling one of the bailiffs. During the course of the trial, we'll take recesses and you'll be permitted to separate and go about your personal affairs just as we did during jury selection. During these recesses, do not discuss this case with anyone, nor permit anyone to say anything to you or in your presence about the case. If anyone attempts to say anything to you or in your presence about the case, tell them that you're on the jury trying the case, leave them at once, and report the matter to one of the bailiffs who will advise me. In every criminal proceeding, a defendant has the absolute right to remain silent. At no time is it the duty of the defendant to prove his innocence. From the exercise of the defendant's right to remain silent, the jury is not permitted to draw any inference of guilt, and the fact that the defendant did not take the witness stand must not influence your verdict in any manner whatsoever. The attorneys are trained in the rules of evidence and trial procedure, and it's their duty to make all objections that they feel are proper. When an objection is made, you should not speculate on the reason why it is made. Likewise, when an objection is sustained or upheld by me, you must not speculate on what might have occurred had the objection not been sustained, nor what a witness might have said had he or she been permitted to answer. During the trial, it may be necessary to confer with the attorneys out of your hearing to discuss matters of law and other matters that require consideration by me alone. It's impossible to predict when such a conference might be required. When we do that, we'll try to do it in a way that consumes as little of your time as is necessary for a fair and orderly trial. If you would like to take notes during the trial, you may do so. You've been provided with a notepad and a pen for your use. Try not to write on the cover page of the notes. That'll keep your notes from being accidentally read whenever they're collected. Do not take the notepads with you from the courtroom during any recess. During recesses, particularly an overnight recess, they'll be collected by the bailiff and locked and secured. After you have completed your deliberations and been discharged from jury service, the bailiff will collect your notepads one final time and turn them over to the clerk, where they will then be destroyed. No one will ever read your notes, including me. If you take notes, do not get so involved in note-taking that it distracts from your listening to and evaluating the evidence. Sometimes it can be difficult to take detailed notes and also pay attention to what you hear from the witness stand. So make sure that that does not occur. And if you take notes, remember that any notes you take are for your personal use. Do not compare your notes with other jurors in determining the content of any testimony or in evaluating the importance of any evidence. Your notes are not evidence, they're not a complete outline of the proceedings, and you should not treat them that way. Above all, your memory should be your greatest asset when it comes time to deliberate and render a decision in this case. On the other hand, you're not required to take notes if you don't want to. That decision is up to you individually. But whether or not you take notes, rely on your memory of the evidence and do not be unduly influenced by the notes of other jurors. Deciding a verdict is exclusively your job. I cannot participate in that decision in any way. So please disregard anything that I say or do that makes you think that I prefer one verdict over another. This concludes my opening instructions to you. I'll have a final, more detailed instruction on the law for you at the conclusion of the case. We will now proceed to opening statements. First from the state, Mr. Bryant.
May it please the court.
Yes, sir.
Counsel? The dismembered remains of the person that used to be Joni Gunter were found scattered in the booby-trapped backyard of this defendant. Joni Gunter's mortal remains were not found by accident. This horrific, shocking discovery was expected. Expected because this defendant, in his own words, described in shocking and amazing detail how he chained Joni Gunter to keep her trapped in his horrific home. He admitted in shocking detail how he trafficked in her flesh by selling her to friends so they could have sex with her for money that he profited from and he kept. This man chillingly and amusingly describes how it's pretty easy to dispose of a body after killing it by using a sawzall, a reciprocating saw, to dismember the remains of a human being and bury them in various locations where they would never be found. He annoyingly describes how in Joni Gunter's case, he didn't have enough time to properly dispose of her remains in the swamp where he wanted to dispose of them. because he was busy cooking methamphetamine in his kitchen. And so he had to cut up Joni Gunter's body with that reciprocating saw and bury her in his own backyards. In 4 different holes in his own backyard. Holes marked with only the memory of the killer that put her there. Why this defendant decided to provide the vivid details of his sex slaves' murders is known only to him. But the evidence clearly demonstrates that this defendant was locked in the Duval County Jail with no expected or anticipated release. At the same time that he was locked in the Duval County Jail with no anticipated or expected release, his home was being condemned by the city of Jacksonville and was scheduled for demolition. And there was nothing he could do to stop the revelation that likely would occur once bulldozers entered his home and started destroying and digging around the foundations. This defendant began speaking to a fellow inmate, Sammy Evans. Sammy Evans, a person who has committed a horrible crime himself, and is facing a lifetime in prison with no anticipated release. So this defendant approached Sammy Evans, and they began to work on their cases together, talking about what kind of motions to file, giving advice on how to handle legal matters. They started talking more and more, and Sammy Evans actually paid this defendant for his legal services by giving him commissary, honey buns, things that had value in the jail, snacks. And Sammy Evans would show gratitude to this defendant for his assistance. The evidence may show that Tillis, this defendant, knew that Evans was going to tell the police about everything they talked about. There is even evidence to show that this defendant knew he was being recorded when he vividly confessed to this crime. His reasons and motives are his own, but Mr. Evans wanted to use this information to help his own case. So he went to the police and tried to convince them to help him. So as you can anticipate, the police said, Mr. Evans, we're going to need 2 things. We're going to need it recorded, and we're going to need the body. Otherwise, it's just a bunch of talk. Mr. Evans provided the recording, and Mr. Evans provided a map with almost perfect detail of where each hole was in the defendant's backyard and where the remains could be found. Because of this recording, you are going to be transported back to Bowden Circle East in Jacksonville South Side in the years of 2014 and 2015. The following are direct quotes from this defendant's own mouth, from his own voice, from his own soul. I will say quote, and everything I say after quote will be directly from this defendant until I close that quote. The property I own is scheduled for demolition. figured, you know, once they go over there and start plowing around on that property, they gonna find something anyway, you know? I know I am fucking dirty. I've been dirty for a long time. I was picking up girls and locking them in that room. And he, end quote, he's referring to his brother, starting quotes again, would come over and fuck them. So I picked up that girl. Now, she was real pretty. She was about 26 or 8, a little brunette. Nice looking. She was real submissive. Jimmy come over and fucked her a couple times. I've been fucking her for about a week, and so my brother came one day, and that day my brother was going to come over and fuck the girl. But when he got over there, the fucking girl recognizes him. She knew him from somewhere. How's that for fucking luck, huh? He freaks out. He says, man, you're gonna kill that bitch. I said, hold up, man, hold up. She's making me money. Jimmy was in love with her. He done gave me $300 one time to fuck her. I said, wait up, man, that girl's making me a lot of money, man. I don't want to get rid of her. I got a couple of guys coming over there and fucking her, and they're paying me, you know what I mean? And she's fucking locked up in a soundproof room. And all of a sudden, she recognizes my brother. My brother. He's like, man, you gotta kill that bitch. And I'm like, hey, I don't want to kill her, right? So he tells me, look. And then I say, look, man, I got something to do this afternoon, referring to cooking the dope for Jimmy. I don't have time to get involved with that right now. Let's just put it off for a couple of days. Nah. He didn't want to leave. Nah. I can't leave, man. You gotta kill her before I can leave. I said, well, you kill her. Man, you take care of her, and I'll get rid of her. I don't know how. Then he starts the talk game, or whatever, and he talks me out of it. So he talked me into killing her. And I told him, I said, man, look, man, I'll kill her, but you cut her up. I'll kill her, but you gotta cut her up, man. I don't have the time it takes, about 4 or 5 hours, to do that, to cut her up and package her so I can move her. And he said, okay, we'll do it that way. We can do it that way. So I killed the bitch, right? So I gave him the Sawzall, the fucking 10-inch all-purpose blade. And I told him, hang her in the garage and tell him, look, man, just cut her up, man. Just cut her arms off and cut her legs off and get her down to the torso and leave her on the plastic. I said, I'll take care of that. So I gave him the Sawzall. So anyway, he talked me into killing her. I kill her. I gave her the Sawzall. He cuts her fucking head off. And then he gets all squeamish. And I gotta get back to the shop. My wife is over there. I got a customer coming, and I got a car that I gotta put out. Blah, 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 blah. I can't stay. He's just talking now to get out of it because he don't want to fuck with it no more. So anyway, he cuts her fucking head off, and then he gets all squeamish, so I fucking finish. doing it right, and then I decide to put her down in my yard instead of taking her down the street. Know what I mean? So I dug a hole in the fucking backyard, put her down. Well, I keep her locked up in a soundproof room. She ain't have no problems. She don't cause no trouble, you know. And you fuck her when you want, and then the guy comes over, you rent her out, you put the money in your pocket, and don't say nothing. You get tired of her, you get rid of her, and get another one. End quote. Towards the end of this recorded conversation, Mr. Evans asked this question to the defendant. Mr. Evans, did you feed them? Do you clean it all up on them? The defendant's answer, yeah, you had to feed them. Oh yeah. It wasn't really personal then. It was more business. End quote. You will hear all of those words clearly for yourselves. And you will hear much, much more. So you have to understand, even for grizzled police detectives, hearing this is somewhat shocking. They still didn't have anything really to go on. They don't know who Joni Gunter is. There are lots of women reported missing, but nowhere in the wire are these women named. The police heard, but when they went to 3551 Bowden Circle East, when they went to this defendant's house, they saw in real life what this defendant was describing on this recording. In the defendant's backyard, they found a torso. In a separate hole, legs and a skull. And a third on her hole, her arms. And a fourth hole, her lower legs and feet. And the only marking of this grave was the map drawn by Sammy Evans based on the distinct description from this defendant. The police now know that that wire was accurate and that body existed exactly where this defendant said it would. But we're still a long way from being here today. This unknown person's remains were gathered and given to medical examiners and forensic anthropologists, experts in trying to learn the truth from decayed bones. They both will come into this courtroom and say that this person, this human being, was murdered based on multiple blows to her head. These blows were circular, consistent with that of a hammer, although they cannot say for sure. The forensic anthropologist will also discuss how she can tell, based on the markings on the bones, that a reciprocating sawzall was one of the instruments used to dismember this body. Because detectives are using the evidence at the scene and then comparing it to what the defendant says to see if it matches. The forensic anthropologist has no idea what the defendant has admitted to in terms of the Sawzall. Interestingly enough, in another part of the wire, the defendant admits that he did not shoot the victim, because that's too noisy. He did not stab the victim, because that's too messy. And in a second interview done by Sammy Evans, 5 days after the first interview, Sammy Evans asked this defendant if he used a hammer. That's not all the police find on Bowden Circle East. They find multiple rooms with blocked out windows, similar to what the defendant describes as a soundproof room. Police find thick chains, iron chains, hanging in the garage, consistent with this defendant's description of hanging the body in the garage to cut her up with a sawzall. They find paperwork in the defendant's home from unrelated multiple women, women with criminal records, women with drug problems, the exact type of women that this defendant describes in his own words. Police find the detailed paperwork, date of birth, social security, name, prison record of a woman named Tabitha Nicole Hogg. They locate Ms. Hogg. And as soon as detectives contact her, she says, "When I saw that Russell Tillis was arrested, I knew y'all would be contacting me." Now, the defendant is not on trial for what happened to Ms. Hogg. I want to be clear about that. But her testimony will show you the truth about this case. Tabitha Nicole Hogg says that she knew Russell Tillis. They were sort of like friends. During the period of time that they knew each other, Ms. Hogg would live on the street. She would use drugs. She would prostitute herself. And sometimes she needed a place to stay and go. And this defendant was that safe place. And one time, she had gone over there after a drug binge. She needed a place to crash. And Tabitha Hogg wakes up at 3551 Bowden Circle East. And she's chained to the bed. And this defendant is raping her. Sounds a little familiar. Somehow, this defendant, in his multiple chainings and unchainings of Ms. Hogg, the last time he doesn't chain her properly, she waits to hear snoring, and she escapes and tries to take her paperwork, flees. She doesn't report it to the police. Who's going to believe a heroin-addicted prostitute anyway? But they found her. Oh yes, they did. Police, in searching the defendant's home, find all sorts of tools that could have been used to dismember, including Sawzall blades. Blades, just like he describes in his wire. They also show pawn slips that in 2014, the period of time where Ms. Gunter could have been killed, they find this defendant owned and pawned the Sawzall reciprocating saw. That was not found in his house, those were found on pawn slips. The blades were found in his home. They find evidence of drug use, similar to that described by the defendant in his own voice. Police talked to neighbors who say they saw lots of women come and go from the defendant's home. And one night they heard a woman scream and say, "Let me go," and then heard what they described as chainsaws. They would always see the defendant pressure washing things like huge rugs. They would see him traipsing back and forth in his yard into the woods with shovels. They also will describe how this defendant kept his home hidden from his neighbors as best he could with large tarps, which would give him the privacy and opportunity to do what he did. And finally, the police were able to make an identification of that torso, those legs, that head, those arms, and those feet. Thanks to the University of North Texas Missing and Identified People's Lab in North Texas, they do DNA testing on remains. And when they did the DNA testing on remains found in this defendant's backyard, they got a match to Joni Lynn Gunter. Joni Lynn Gunter, a girl who wrote on her Florida ID card, because your license was suspended, she couldn't drive. On her Florida ID card, her address was Sulzbacher Center. A woman that had been in and out of prison, a woman that had prostituted, a woman that had drug addiction in her life. The exact type of woman described by this defendant. But Joni Gunter had a family that loved her. And although they did not report her missing in the formal sense of the word, her sister Ashley Gunter had posted in social media, "Hey, has anyone seen my sister?" Although we haven't seen each other, we go for periods of time without seeing each other, it's been too long. We should have seen each other by now. And obviously Joni Gunter could not make those calls. Now I anticipate that there will be claims that this confession is a make-up play, movie, skit, drama. So this defendant can get a death sentence because he was depressed. But you're going to have the opportunity to listen to that wire, to listen to that recording. And you will know that this man's very, very small backyard was littered with the decaying body parts of a human being, littered with the body parts of Joni Gunter. And his underlying motives for why he admitted this are irrelevant when the police are standing over and exhuming Joni Gunter's dismembered and murdered body. You will know the truth when you hear from Tabitha Nicole Hogg, who had almost an identical experience only to escape. When you see the photographs of this defendant's home and weigh all the corroboration that exists, you will know the truth. That this defendant bashed in the head of Joni Gunter with premeditation, and during the course of the kidnapping, confining her, and during the course of the human trafficking, where he was selling her flesh for money. You will find that this defendant dismembered and disposed, grossly abusing the dead body of Joni Gunter. The evidence is shockingly and overwhelmingly evil and true. And we are confident in your eventual verdicts of guilty as charged to each of the 4 counts of the indictment. Thank you.
Thank you, Mr. Mizrahi. Collector?
Thank you, Your Honor. And please, court.
Yes, sir.
Counsel.
Yes, sir.
Good morning, ladies and gentlemen of the jury. My old law professor said, criminal cases are simple. The Constitution makes them simple. It's either the state proves their accusations beyond a reasonable doubt with rock-solid evidence, or it's not guilty. We talked a little bit about the right to remain silent in jury selection. And the fear of a criminal defense attorney is that if you don't put your client on the stand, the jury will think he's hiding something. Well, this week, Russell Tillis has nothing to hide from you, and he will take that stand. And he will subject himself to the same bright lights that all the other witnesses will subject themselves to. You will hear from Russell Tillis, and what he is going to tell you is something he's been trying to tell everybody since the day he was arrested in this case. Russell Tillis was in jail. He was in this courtroom being prosecuted. His judge was Judge Barilla, a different prosecutor. It's kind of a weird case. He was accused of pulling a knife during an argument with some cops late at night at his house. And he got frustrated because his lawyers, his court-appointed lawyers, wouldn't help him. He was told by the court he could be getting 30 years in that case. 30 years. And he did not want that to happen. He got depressed. He complained about his lawyers. Get the neighbor's surveillance tape that'll prove that I didn't do what they said I did. He gets depressed. He gets emotional. He sits in jail and just languishes month after month. Convinced he's going to get 30 years on a case where he really didn't do anything. He got roused out of bed in the middle of the night by the police, walks outside, and they accuse him of all kinds of things. And there's just no way to fight that. So he comes up with a plan. He talks to an inmate named Sammy Evans, a fellow inmate who is looking at the rest of his life in prison. He comes up with a plan. We can refer to it as suicide by state. You see, he knew about the murder of this young lady. A person who he'll tell you about pulled up to his house and her dead body was in the trunk. He knew about that. And he thought, you know what? I'm going to make up a shocking story. He will tell you his reasons and his motives for doing so. So he makes up a story about human trafficking, abuse, all kinds of things. He makes up this story and he spoon feeds it to Sammy Evans. Sammy Evans spoon feeds it to a detective. The detective spoon feeds it to a state attorney. And he gets charged with the murder based on what he said. As time goes by, the case he was originally in jail on, he gets time served. It goes away. And now he's stuck. He's confessed to a murder he didn't commit. He's confessed, and he's made the confession so shocking that it guarantees he gets the death penalty because of what he says in it. It's just so shocking. It's so aggravating. It's so personal. He made up all those details so that he wouldn't have to sit in prison for the next 30 years. Well, then the case goes away, and now he's looking at the death penalty because because he knew where a dead body was buried. He got so depressed at one point when he was looking at that 30 years that he ate every pill he could get his hands on in the jail, other people's medications, trying to kill himself. He actually spent a couple days in the hospital over that. He made that story as shocking as possible. He talks about chaining women to the floor, shackling to the floor, raping them repeatedly. But when you listen to the story, it starts to sound made up. It starts to sound ridiculous. He tells Sammy Evans, yeah, I was raping this one girl. She liked it and kind of became her girlfriend. She liked it. Then she started cooking and cleaning for me. I had to run her off. That's how ridiculous the confession is. He goes into, yeah, I have all my friends come over and have sex with her. And they pay me. We chain her to the floor in a soundproof room. And you'll see the pictures of the house. If putting up a blanket over a window to keep the light out makes your room soundproof, well, I guess it's soundproof. But that's not a soundproof room. He makes it as shocking as possible. He tells a story about how he needed to get from A to B one day. So he just happens to be at a gas station. Doesn't tell how he got to the gas station. He just says, I'm standing there, guy gets out of his car, leaves his keys, I jump in, I drive off, and then I realize there's a Pinto behind me following me. And I pull into the house. I make a couple turns, I pull into a driveway so I can turn around, maybe shake this car. It just so happens, according to his ridiculous story, that he's at the owner's house, the guy that owns the car. And it's the daughter behind him saying, what are you doing at my dad's house in my dad's car? That is the most ridiculous, fantastic story ever. Sammy Evans just buys it, goes right along with it. So now he's stuck with this confession to a murder when he didn't do it. So what does he say? He says, get Sammy Evans in here. Sammy knows. Sammy told me he was wired. I told him I'm going to spoon feed him this story. Not only that, it's going to help Sammy. Sammy's going to get what's called substantial assistance. I'm going to get my death by suicide. I'll go off and get executed so I don't have to die a long, languishing death in Florida State Prison for 30 years. He's about 60 now. Guys don't live very long in prison. It's not fun. Bring Sammy Evans in here and ask him. He knew this was a hoax. This whole thing was a hoax. After 3.5 years, he comes to court one day and he writes on a piece of paper, I'm liable. And he tells the court, tells everybody, as we're all standing in here, Sammy Evans knew and I knew that he was liable. He told me. He held up this piece of paper, I'm liable. Thus giving me the sign, let's talk about this case. Here comes the confession. This is going to get me my death by state, my suicide by state execution. More time goes by. Finally, guess what happens? Sammy Evans says, okay, he knew I was wired. I told him. He's in on it. He's in on it because it gets a big chunk of his time that he's looking at taken off. You'll hear about how it works. So that's what you have. You have this shocking, made-up confession. Did he know the body was in the backyard? Yes. But everything else, everything in that confession is fake. He didn't do it. He knows who did it. he'll tell you that. And he's been dying to do so for years. And finally, Sammy Evans came clean the other day. And here we are at the very trial that we'd asked for. And at the end of it, we're going to ask that you find Russell Tillis not guilty. Thank you.
Thank you, Mr. Fletcher. Members of the jury will take a brief morning recess. Remember, during this recess, as with all of our recesses, do not discuss the case, do not discuss anything about it, and leave your pads on your chairs, and we'll see you back in just a few moments. Court will be in recess for 10 minutes.
Okay,
So
Alan.
it's not a rush. It's not a rush. Everything's marked. Here's the list. This is court exhibit.
Okay.
So that's just court exhibit. It doesn't go to the jury. Everything else goes to the jury according to this. The last two things I'm not doing.
Please make sure you're wiping down.
Yeah, I forgot last time. I'm gonna try. So those two I'm not doing. So the wire's the last thing.
Gotcha.
Almost. That's the wire. And then everything else should be in order.
Cool. Thank you.
Judge has got the copy.
I'm gonna display everything.
Did you only got it?
He's got a copy. So I guess when he gets done with it, we give it to us. So I guess this is the original.
Anyway, you move that back, because, hard to see when the jurors over there.
This is the order, I think the order that they're gonna do the pictures in.
That part, those pictures, when we did put this before,
When I get there tonight, you gotta show me. But look, you said you weren't testifying, so you kind of got.
So
better.
Whatever they call witnesses in, you made it, I'll get up. Because I guess they're gonna have to stand here somewhere. Maybe they can still stand here and just raise their hand.
Put them in the center.
But there was years of fish coverage. This was done on one occasion. That's it. I don't have evidence that she's done every single day.
Not need to be on the record, but for everyone, a reminder, the trial is being live streamed, and I'm getting text that your comments and conversations are going out, so be very cautious of what you say.
Okay. What's that? If the microphone is not on, is it going out?
It's supposed to be on when my house recess is supposed to go off, but all I'm saying is on the. Recesses, if I were you, make sure you're doing it.
June 10. Yes, sir. Well, we got a minute.
All right, let's go back on the record. Of course, the jury's not here. During the recess, the court did have an opportunity to review Mr. Tillis's latest written Nelson petition. It alleges several matters, one of which Mr. Tillis was stating on the record this morning before the court said I would review it in writing, dealing with, he wants Mr. Fletcher to investigate and find a witness named Cliff. It also indicates that he would like to have witnesses by the name of Schneider and Haywood, who I believe are doctors, testify to his depression that was alluded to in Mr. Fletcher's opening statement. And then there's a witness, Christie, that he wants Mr. Fletcher to find and investigate and potentially call. And he makes reference in there to a list of 23 witnesses, I think, in total. So, Mr. Fletcher, what is your response have you had an opportunity to view this entire document and/or the matters that I just summarized? So you've attempted to locate this person? No, I understand. I think that's an appropriate response. How about Christie? I don't recall one being in the document. Okay. All right. And okay, how about, as I said, he mentions at the end, and 23 witnesses in total. I think we just mentioned 1, 2, 3, 4. I know it's virtually impossible for you to say off the top of your head who those may be, but are you aware of any witnesses that Mr. Tillis has informed you of that he would like to have called that, in your professional opinion, you have been able to locate and that they would provide meaningful, relevant, exculpatory testimony? Well, yes, but be cautious in terms of your only tell me what you believe you need to tell me in order for the court to rule on this Nelson petition. And I think you have. I think the answer that you just gave, frankly, is sufficient.
The witnesses just aren't helpful, and a lot of them, every witness is sort of a double-edged sword.
Let me just make something clear on the waiving of attorney-client privilege. Obviously, if it becomes necessary, we can have an in-camera proceeding. I don't think it rises to that level. Again, I'm satisfied with the answer that you have given.
Okay. And Judge, the only thing I'll add is I did allude to, I think it was last Thursday, some of our meetings with Mr. Tillis are very combative, and I'll just kind of end it there, and it makes it difficult to do anything.
No, I understand. You've informed the court of that before. And I think I've spoken my piece on that as well. All right, based on the court's review of the, it's not styled that way, I know, but the court's construing it as Mr. Tillis's latest Nelson petition. The court has reviewed it, considered the response from counsel. The court at this juncture finds no reason to believe that Mr. Fletcher is performing his duties in a less than competent fashion, that he is rendering competent effective representation for Mr. Tillis, and that the matters contained therein do not rise to the level of the court needing to inquire further. Therefore, the petition, as the court is construing it after a Nelson hearing, is denied.
I would like to place on the record, Your Honor, that
If you're objecting to the ruling, that's
no, sir.
done.
I was going to add that what you're reading is simply notes. It was not the entire complaint. There are other issues revolving around Mr. Fletcher's representation.
All right, Mr. Tillis, if you have any other matters that you wish for the court to consider, place those in writing, and I will consider them.
Well, I would.
Thank you, sir. That's the end, Mr.
I
Tillis.
was anticipating an oral.
That is the end of the discussion for now. Place any other matters you wish for me to address in writing, and I will consider them. Mr. Fletcher, Mr. Mizrahi, are we ready for the jury to come back?
Yes, Your Honor.
All right, let's bring the jury back.
Your Honor, may I address the court?
No, sir. At the next break, you can. The jury is about to enter the courtroom. Remember, members of the jury, just go ahead and have a seat when you come in. Thank you. Okay, thank you. Everyone may be seated. Today, call your first witness.
They called Melinda Bryant.
Do you solemnly swear or affirm the testimony you shall give shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you, ma'am. Have a seat right there. And members of the jury, just so you, go ahead, Nancy. Just so you know, the configuration of the courtroom when this courthouse was built, this is one of the two courtrooms in the building that has two jury boxes. It was designed for two jury trial cases. Of course, this is a one jury, but given the conditions of the pandemic, keeping you socially distant and spread out, we've got you occupying the two jury boxes. However, the design was such that the actual witness box cannot be seen by part of this jury. Brilliant. Nobody asked me how to design it, I suppose. But in any event, that's why, for our purposes of the trial here, we have we're utilizing this space for the witness box. So in just case you're wondering why it's configured that way, that's the reason. So, all right, State.
May it please the court.
Yes, sir.
Please introduce yourself to the jury.
Melinda Bryant,
Miss Bryant, where do you live?
3603 Bowden Circle East.
Miss Bryant, I'm going to ask you to pull the microphone down a little bit if you can. Where do you live again?
3603 Bowden Circle East.
And how long have you lived there?
off and on since 1968.
Okay, was that home part of your, or the land part of your family?
Yes,
Okay. Back in approximately from 2012 to 2015, did you have a neighbor to the right of your home, if you're in your home?
yes.
And who was that person?
Russell Tillis,
Do you see Mr. Tillis here in court?
yes.
Did you say where he's seated and what he's wearing?
Sitting over there, and he's wearing a gray suit, and he's got a white mask on and his hair pulled back, or gray hair.
Your Honor, may the record reflect that witnesses identified the defendant.
The record shall so reflect.
I want to show the jury a few, could you just, let me ask you this before I show the pictures. Could you describe the condition of the home next door to you during that period of time between 2012 and 2015?
We had it all draped up with tarps and boards, and it was pretty bad.
Were you able to see everything that was going on in that home or in that yard?
Not everything. I could see parts of it because he didn't have it draped off all the way.
Is there a situation where you heard a girl screaming?
Yes.
Could you please tell the jury about that?
It was dark. I don't remember the day, but it was dark, and I could hear somebody screaming, and I called my neighbor, Annette, and told her to come over and see if we could see anything. So we went to my back door, and I kind of opened it and peeked, and I kind of shut it back because I was scared he could see me, but we could hear somebody screaming, and then all of a sudden it was loud noises. And then and you could see shadows, you know, it was dark, and I could see shadows all back there, and I guess a saw or pressure wash, I don't know what the noise was. It sounded like a saw, but he's always got noises. And but I didn't see it. But I did hear the girl scream.
And then after the girl screamed, can you be any more specific about what you heard in terms of the machinery?
Of a machine?
Yeah, like what do you think it was?
A saw, it sounded like.
Now, your home is right next door to the defendant's?
Right next door.
During the course of you living next door to the defendant, was he commonly using saws to cut things?
Yes,
Was the defendant, did he ever use a pressure washer?
all the time.
Tell the jury about that.
About it wasn't night, it was morning. He was pressure washing 2, 3 o'clock in the morning, anything and everything over there. And all night long.
Did you ever see the defendant digging in his backyard or look like he was digging in the neighborhood?
I couldn't see him digging.
Did you ever see the defendant with a shovel?
Yeah, you could see on his truck, he had tools, but I didn't see it.
Was there ever a time that you met a woman that was living with Mr. Tillis during this time frame?
Did I met her? Yes.
Can you describe for the jury how that came about?
He was in 2012, the end of 2012, he built some rails. Or the beginning of 13, I really can't remember. The beginning of 13, I had some steps and I needed rails built. And he came over with his girlfriend that he'd been seeing for a while. And he sat out there and built the rail, and she sat in a lawn chair. And that's how I met her. Because the other ones, no one ever met.
Okay. Did you see girls coming and going from that place?
All the time.
And are you able to relate any of these incidents to when your father passed away?
My father died in 14. He came over there after he built the rails in 13, and I didn't see the girl anymore because that's when he put all of his stuff up. I couldn't see no more.
And you were shown pictures by the detectives to see if you could identify Joni Gunter, and could you do that?
I showed the picture that I thought I knew.
Okay, but you're not positive, is that?
I'm not positive.
We'll go through a few of the pictures, and you can just describe for the jury what's in the pictures. And Ms. Bryant, you can actually, on the screen next to you, you can actually use it kind of like a telestrator and circle things. It'll come on in a second. Do you see State's Exhibit 1? You see that?
Yes, sir.
Okay. Could you please circle your home? Could you please circle the defendant's home? And just for the record purpose, Ms. Bryant, are both of these homes located in Jacksonville, Duval County, Florida?
Yes.
In this photograph, Ms. Bryant, can you kind of show the jury the back door where you were trying to peer through and see, you saw the shadows and the screaming and the saw?
It was back here in the back side of this room back here, and he was back here.
Okay, so in the backyard of his home, in your home.
Yes.
I'll show a series of other photographs. State's Exhibit 2, do you recognize this?
Looks like his backyard.
Okay. State's Exhibit 3, what are we looking at here?
That's when he's had it all tarped up.
And could you please circle your home as well as the defendant's home? First your home, and then the defendant's home. State's Exhibit 4. Is that the same type of tarping? Ms. Bryant? Is that similar tarping to what we saw in State's Exhibit 3?
Yes.
Okay. That's all the questions I have, Your Honor.
Okay, thank you. Make sure we're wiping the podium down there. Mr. Fletcher, cross-examination.
Momentarily.
All right, sir.
Ms. Bryant, you lived next to Mr. Tillis for a long time, right?
Yes, sir. Off and on.
Okay. And would it be fair to say you don't like Mr. Tillis?
Did I like him?
Would it be fair to say you don't like Mr. Tillis?
No, I don't.
Okay. He was loud, right? House was loud, right?
Yeah.
Called the police all the time, right?
Yeah.
That the police got tired of you calling, right?
Yep.
So if there was noise going on at night, you'd call the police, right?
Not every time. After a while, I quit. Yep.
So hearing noises and yelling and screaming, is that kind of an everyday thing for you guys?
Well, yeah. In the middle of the night, 2 or 3 or 4 in the morning.
And you watch a lot of news stories about this case, right?
Yep.
You follow it closely, right?
Yeah.
Okay, so about when was it that you heard the screaming and then a saw? When was that?
I don't know when it was. It was after my father died.
And what year was that?
14,
What month?
March. And we had to get,
Approximate? How long after that you heard the screaming and the saw?
no, because it was all the time, and I was scared to death of this man, so I don't know.
Remember a time when the police came out and started putting tape all around the house and going through everything? Remember that?
No, I don't think I wasn't home when it first started. When I got home, I seen it.
But at some point, they started doing sort of an excavation of the backyard,
Mhm.
searching the house, and it took several days, right?
Yes.
And during all that time, did you approach an officer and tell them about the details that you told us?
No.
And that night when you heard that screaming and that saw, did you call the police?
I didn't, Annette did.
Okay. But being concerned, you didn't talk to the police that night, right?
Yeah, we called them. Annette called them.
Yeah, but you didn't talk to the police.
No, because I told her to call them.
Told Annette to call the police.
Yes, because I wanted to make sure I kept listening to what was going on.
Okay. But when the police got there,
They didn't come.
they didn't even come?
Nope,
Nobody showed up a couple hours later?
nope.
You sure about that?
I'm positive.
Okay. And then over the years, you watched all the news coverage, right?
Nope, not all the time.
I'm sorry. I just asked you if you watched a lot of news coverage about this story, right?
Yeah,
Is your testimony today influenced at all by what you've seen in the news?
no,
No?
no.
Okay. Do you think that the detail that you heard a person screaming and then you heard a saw would be something important to tell the detectives when the detectives came out and interviewed you?
I quit telling any of the authorities because no one would listen to us. No one.
Did some detectives eventually come out and sit in your living room and talk to you?
They didn't come in my living room, they come on my porch and showed me some pictures.
Tell them any of the details that you've told us today.
Nope,
Okay. So 2014 goes by, 2015 goes by, 2016 goes by.
Yep.
Right? And then the houses get searched and it's get taken apart, right?
mm-hmm,
And 2017 goes by, 2018 goes by, and then in about 2019, you're sitting in a room with me and Mr. Mizrahi,
Mhm.
right? And you're giving a deposition, right?
mm-hmm,
The 5 years have gone by, right?
Mhm.
And all of a sudden you say, I heard a person screaming, and I heard a saw, right?
mm-hmm.
And even Mr. Mizrahi looked surprised, right?
Sustained.
Remember how we reacted when you said that?
Sustained.
That was the first time you told anybody?
No, I told everybody that I knew.
Yeah, but you didn't tell the police when they were sitting on the porch, right?
I asked the news people if this girl had a lisp or she talked funny. It's the only thing I wanted to know, because I know that was the girl in my yard. It's the only thing I cared about.
Back in 2012. That's when you met the girl that he was dating?
Yep. Or it was 13. It was either 12 or 13, because like I said, I'm trying to remember. There's a lot going on in my life. I can't remember the date, the year. Just don't.
Thank you, Judge.
Anything else for the witness? Yes, sir. One of those COVID rules, we're making them, making the attorneys do that.
He kept beating me, so I finally got one up on him. Ms. Bryant, Mr. Fletcher asked you why you didn't like the defendant. I mean, he asked you if you liked him or not, right? Remember that? Is there a reason why you don't like the defendant?
Yeah, because he threatened to kill me all the time.
Tell the jury about that.
Threatened to kill me. He would jump the fence, jump over it, and peek up. He watched me 24. I couldn't get my car. I had my neighbors checking to make sure I was home. Didn't take showers after dark. I had to get bolt locks on all my doors.
Thank you. That's all the questions I have, Your Honor.
Okay, anything else for the witness?
Ever act on that threat to kill you?
He didn't never put his hands on me.
It's just a lot of talk, right? Again, how many times do you think you called the police on the house over the course of a couple of years?
Me personally, probably about 30, 40.
Were there times where you were up late night drinking or anything like that and called the police?
Not drinking.
Up late at night? Calling?
I was up because I couldn't sleep.
Fair to say, cops came out a bunch of times and never did anything, right?
Nope.
Anything else for the witness? All right, thank you, ma'am. You're free to go. Thank you.
Thank you.
Officer Miller, make sure we're sending the witnesses back out through the, are we doing it through the middle or on that side? Yeah. State, call your next witness. Thank you, ma'am. Have a seat right there.
May it please the court.
Yes, sir.
Please introduce yourself to the jury.
My name is Annette Campbell.
Okay, Ms. Campbell. The jurors are on both sides, and I know you seem to be a little bit nervous. It's okay. All right, if you could pull the microphone a little bit closer to your mouth, that'd be great. Can you tell the members of the jury where you live?
I live at 3604 Bowden Circle East.
How long have you lived there?
I've lived there for 47 years.
And do you know the Tillis family?
Yes.
And where do they live in relation to you?
They live across the street and to the left.
You know Russell Tillis?
Yes, I do.
And was he living across the street from you between the years of 2012 to 2015?
Yes.
Do you see him here in court?
Yes.
Would you say where he's seated and what he's wearing?
He's seated to my left in a gray suit with glasses and a white mask.
May the record reflect the witness has identified the defendant.
The record shall so reflect.
I want to turn your attention to an incident that took place where Gail Bryant, your neighbor, called you over. Do you remember that?
Yes.
Would you please tell the jury about it?
It was late one evening. The street lights were on. It was dark. She asked me, she said, "There's something going on next door. Come over here." So I went over there, and we went to her laundry room, and we could hear what we sounded like a woman screaming for help.
Did you hear the words that person was saying?
It sounded like she was saying, "Help me."
What happened next?
We listened for a while, and then we heard what we sounded like a saw or a motor or something running. We called the police and told them what we heard, and we waited and we waited. Seems like a couple hours, and I finally went home.
Did you ever speak to the police that night?
No, not that night.
Can you describe for the jury, did you ever see the defendant with shovels or digging or anything like that?
Yes.
Please describe that for the jury.
It was a few times he would be out in the front of his property in the culvert of the ditch, and he would be digging out there as if he was going to be putting a driveway in or something like that.
Did you ever see him coming out of the woods or anything like that?
Yes.
Describe that for the jury.
I would go pick up my granddaughter at school at 3 o'clock in the afternoon, and as I drove around Bowden Circle and stopped at a stop sign at Belfort Road, a few times, I'm not sure how many, I saw him coming across the road with a shovel in his hand.
And is this the area where Pottsburg Creek runs?
Yes.
Can you describe for the jury how the defendant's home was in terms of fencing and tarps and things like that?
He had, like if you were looking at your property, one side and another, there were great big high poles with a rope strung across it, and he had blue tarps that hung from the high in the air all the way to the ground, so you could not see into the yard.
Did you ever see the defendant using any type of saws to cut things in his yard?
Yes.
Did you also see things like a pressure washer?
Yes.
Can you describe seeing the defendant use the pressure washer?
There was one time when he was
he had a rolled up piece of carpet attached to his bicycle, and he was riding down the road pulling the bicycle behind him. And then he was gone.
Bicycle behind him or pulling the carpet behind him?
Pardon me?
Pulling the bicycle behind him? Or
No,
pulling-
he was riding the bicycle with the carpet attached, pulling it down the road. And then the next time I saw him later that day, the carpet was strung across a big rope thing, and he was pressure washing it.
I'm going to show you a series of pictures. You have a monitor to your left. See that?
Yes.
Okay, so I'm going to show you a series of pictures. Beginning first, I'm going the wrong way. With State's Exhibit 1. Do you see that?
Yes.
Could you please circle the defendant's home?
With my hand?
Yes, ma'am. You know whose home is just to the right?
Yes.
Who is that?
Gail Bryant.
Is that the home you went to when you heard the girl screaming for help?
Yes.
Can you kind of show the juror where you were when you heard those screams?
It was back in the back here, in the back of the house. There's a door back there.
Showing you State's Exhibit 2. Do you recognize that photograph?
Yes.
What is it?
That's Rusty's house.
And is that fairly inaccurately depict what Mr. Defendant's house looked like between 2012 and 2015?
It does, except I don't see the blue tarp that's hanging to the ground.
Okay. State's Exhibit 3. What do we see here?
Yes, that's it. That's the blue tarp that hung to the ground.
And State's Exhibit 4.
Yes.
Can you describe how the defendant would enter his home, go back and forth?
Well, there were times when he would walk in, but sometimes the gates would be open, and he would drive his vehicle in, and he would drive it like through the tarp, and it would raise up, and then as he drove in, then it would fall back down.
Showing you State's 56. Can you show the jury where Bowden Circle East is on that map?
It's right in here.
And can you show the jury where Pottsburg Creek is?
Goodness.
It is labeled on there,
Yeah. It's down in here. Yes, I see now.
So it's basically right next to Ballard Circle East and Belfort Road,
Yes.
where you were describing you were at the stop sign.
Yes.
Show you a couple more of these. State's Exhibit 57. We see 3351 Ballard Circle East. Is that the defendant's home?
Yes.
Would you circle your home for the jury? You're really basically right across the street.
Yes.
And then State's Exhibit 58. Does this fairly and accurately depict what Pottsburg Creek looks like in the corner of Ballard Circle and Belfort?
Yes.
That's all the questions I have.
Okay, thank you. Cross? Yes, sir.
Ms. Campbell, you said that that night that you heard the screaming and then I saw of some sort that Annette called the police.
Pardon me?
Said that your friend called the police that night?
I believe I was the one that, I don't remember. I don't remember who called the police. One of us did.
But you never talked to the police that night?
No,
Neither of you did.
no.
About what year was this?
Oh, my goodness. I don't remember the year.
But screaming happened all the time at that house? It was
Yes.
late at night, partying, that sort of thing, right?
Yes,
Running power tools all the time?
yes,
Pressure washers all the time?
yes.
So seeing him pressure washing a rug out front, is that unusual?
No,
That sort of stuff all the time?
yes.
What kind of work did he do, you know?
I didn't know that he never worked that I know of.
Well, he would go off during the day and come back, right?
Yes,
Something during the day, right? Had tools all over the house, right?
I never was in the house.
Ever build something for your friend?
He built a porch for her.
Well done.
Yes, as far as I know,
So from a construction standpoint, he knew
yes.
that's what he did.
I don't know.
Don't know really when this screaming and chainsaw thing was or saw thing was, right?
It had to be around 2000, the end of 2014, 2015, maybe. I'm not sure.
Detectives come out and talk to you after his house got roped off and there were police out there and all that stuff?
Yes,
Tell them about that?
yes,
Tell them about the screaming and the chainsaw?
yes.
Or it was, do you remember which detective?
I did talk to Detective Sullivan, but I'm not sure it was him that we talked to that night. Or not sure if he's the one I talked to.
But over the years, you've seen all the news coverage in this case, right?
Yes,
And more, as it went on and on and on, as the case progressed through the court system, more details came out into the papers, right?
yes.
Did those details ever influence anything you said?
No,
Recall a young man living on the property in a trailer, sort of between Tillis's house and your neighbor's house?
yes. No,
Remember where the trailer was parked?
yes. It was parked, me looking at it to the right.
So if I'm standing at the foot of his driveway, looking that way towards where the tarps were in the garage, it's to the right-hand side?
Yes.
Thank you, ma'am, that's all I have.
Okay. Anything else for the witness? Thank you, ma'am. You're free to go. Stay call your next witness.
Call Sammy Evans.
Sir, if you'll stand right there in front of Madam Clerk, please. Thank you, sir. Have a seat.
May it please the court.
Yes, sir.
Please state your name for the record.
For the record, my name is Sammy Ortega Evans.
And Mr. Evans, you're sort of soft-spoken. I know you're wearing a mask. If you can push it down, and I guess the counsel and I have a moment, Your Honor.
Yes, sir. Yeah, that's fine. I know the assigned mask there that Mr. Evans is wearing is rather thick. And Mr. Evans, pull your chair towards the bar there as close as you can. I know it's a little difficult for you, but.
This works a little bit better.
Yes, sir.
Okay. So you stated your name for the record, and Mr. Evans, where are you currently living?
I currently reside in the Duval County Detention Center.
Mr. Evans, have you pled guilty to your charge?
Yes, sir, I have.
Are you facing a possible life sentence as a habitual offender for your charge?
Yes, sir, I am.
And has the state made any deals with you in order to get you to testify?
No, sir, they have not.
Before you pled guilty, were you facing a mandatory life sentence?
Yes, sir, I was.
And now, are you facing a mandatory life sentence?
Yes, sir, I am.
Mandatory mean that's the only sentence you can get is life, or you could get life?
I could get life. It's a possibility.
Could you get something less than life?
Yes, sir, I can.
Was that the only negotiation in your case?
Yes, sir, it was.
In addition to the fact that the state only made you plead to one of your charges as opposed to multiple charges.
Yes, sir.
When you pled guilty and the state waived your mandatory life sentence, had you already cooperated in this case?
Yes, sir, I had.
So you pled guilty facing a potential life sentence after you provided your cooperation in this case?
Yes, sir, I did. I actually provided the cooperation a year before I pled guilty. I was continuing to fight my case.
Who will decide your sentence, Mr. Evans?
The Honorable Judge Borrello, sir.
Okay. Is the state going to decide your sentence?
No, sir, it's not.
Do you hope that your cooperation will help you?
Oh, yes, sir, I do.
But do you know what sentence you're going to get?
No, sir, I have no idea.
And are you prepared if Judge Borrello gives you a life sentence?
I've made my peace with God.
Mr. Evans, how long have you been currently incarcerated in the Duval County Jail?
I've been incarcerated in the Duval County Jail 2 months shy of 7 years.
Almost 7 years.
Yes, sir.
Okay. As an inmate, Mr. Evans, can you describe what it's like in the Duval County Jail when people know you are cooperating on a case?
It's extremely tough.
Just keep your voice up, Mr. Evans. I'm having a hard time hearing you.
Excuse me, sir. It's extremely tough. You're a pariah. You're an outcast. A lot of people are going to be antisocial. A lot of people are going to mistreat you. It's constantly a trying ordeal.
Has it been trying for you, Mr. Evans?
Yes, sir. It's been really tough.
Is fear an element as well?
Yes, sir, it is.
I want you to describe for the jury how you came to know the defendant, Russell Tillis.
We were housed in the same dormitory, but not the same sleeping area. So I would say the common area we shared. And he was known for being pretty good as far as writing legal motions. And like I said previously, I was fighting my case. And so I had an opportunity to see another motion he had written for one of my roommates. And so he introduced me to him. And I had written up a motion, and I wanted him to transcribe it.
Okay. Do you see Mr. Tillis here in court?
Yes, sir, I do.
Would you please say where he's seated and what he's wearing?
To my left with a gray blazer, white face mask.
A white face mask?
Yes, sir.
Your Honor, may the record reflect the witness has identified the defendant.
The record shall so reflect.
I want to be a little bit more clear about the housing in the jail, as our jurors may not be familiar with that.
Yes, sir.
Can you be a little bit more vivid in your description of how there's cells and then there's a common area? What is that like?
In the dormitory, there's approximately, I'd say 12 cells on the bottom and 12 cells on the top. Each cell houses 3 inmates. The common area is the day room where you come out and you can sit to the card tables or eat your lunch out there, and it has 3 phones on one side and 3 on another, with a common shower area towards the wall.
So if you're in the same pod as an individual, is there a lot of time that you can spend together?
Yes, sir. The doors are unlocked around 8 o'clock in the morning. They don't lock them again until 10:30 at night, so about 12 hours maybe.
It's the only time you're restricted to your cell itself is at night.
Yes, sir.
Were you the only inmate that saw the defendant was doing good work on motions and things like that?
No, sir, I wasn't. It was common knowledge in the dorm.
Did you ever see fellow inmates use the defendant's services?
Yes, sir, I did.
Did you see those fellow inmates pay the defendant?
No, sir. It was also known that some people had taken advantage of him and refused to pay him, but I wasn't one of those guys.
All right, describe that for the jury.
My roommate said that they weren't going to pay him, and then other guys said that they weren't either. And I decided to pay him because I just felt like it was the right thing to do, and that what they did wasn't right at all.
Could you have gotten away with not paying him?
Yes, sir. I believe I could have, because I observed other people get away with it.
When you say pay, how do you pay?
With commissary items that we're allowed to purchase off of the canteen.
Like what?
Potato chips, pastries, cookies, and things of that nature.
So what happened after you paid for the defendant's help in your case?
Him and I began to talk more and deal with each other more frequently.
All right, and tell the jury how it led to you becoming involved in this case.
I was actually sitting in my bedding area, and he came and he knocked on the door. And the doors are already locked backwards, but it's just procedure what a lot of guys will do before they enter. And I told him to come in, and he said actually he'd like to talk to me in person, and could I step out? And so I stepped out, and we went to the corner of the dorm, which is under the stairwell, and that's how we began to talk.
And was that a little bit more private?
Yes, sir.
Okay. Tell the jury what happened next.
Mr. Tillis asked me had I ever cooperated on a case before, and I told him no. And he asked me how would I feel about cooperating on a homicide.
Your Honor, I want to make sure the jurors are hearing all of this, because it's hard.
Members of the panel, are you able to hear and understand the witness? Okay. They are indicating yes.
Okay, thank you, Your Honor. Okay, so what did you say? You said yes?
I told him yes.
Okay. Had you ever done that before?
No, sir, I had not.
All right, tell the jury what happened next.
He began to tell me what it would consist of and what I would have to do, and he told me what he thought I'd be expecting as far as the police coming to talk to me and things like that.
Okay. And were you willing to help?
Yes, sir.
Did you want that help to help you?
If it came, I would definitely be grateful.
Was there ever any indication from you that the defendant was telling you lies about anything?
At first, I didn't know. I was skeptical. I didn't know if he was telling lies or not. So I really didn't know. I didn't know what to expect.
Okay. So you went in with an open mind.
Yes, sir.
All right. Mr. Evans, tell the jury what happened next.
I wrote a letter to the Jacksonville Sheriff's Office, and the detectives came and pulled me out and questioned me. And they told me that they would need more details and more specifics in order to give me a recording device. And so I came back to the housing pod, and I told him, and he told me exactly where the victim was located in his yard, buried. And so he showed me a map. He drew a map and told me I would have to memorize it and be able to draw it in front of the detectives. And so I did. And so when I contacted them the second time, they came and got me, and I drew the map for them, and they gave me the recording device.
In your first meeting with the detectives, did you have a lot of details?
No, sir, I didn't.
Did you have some details?
Yes, sir.
And then after going back and talking to the defendant, you were able to get more details because you drew a map.
Yes, sir, I was.
And did you sign that?
Yes, sir.
Did you date it February 5th, 2014?
Yes, sir.
I'll show that jury the map in a little bit. So after providing the map, did you get a recording device?
Yes, sir.
Tell the jury what happened next.
I came back to the dorm and I wrote on a piece of paper that I had the wire, and so he instructed me to follow him, and we went to an empty cell that wasn't occupied, and I sat down, and he began to write questions for me to ask him, and I asked him the questions on the recorded device, and later on the detectives came and pulled me out again and took the device from me.
So I want the jury, what do you had some details before you went in there?
Yes, sir.
And did you know that there was a body that was dismembered in the backyard of Mr. Tillis's home?
Yes, sir.
Okay. When you sat down and he started telling you questions, what did you do? Ask those questions?
The questions he told me to ask, yes, sir, I did.
Whose idea was all of this?
Mr. Tillis?
Did you ever intimidate him or threaten him in any way?
No, sir, I had not.
Did he freely and voluntarily tell you all these things?
Yes, sir, he did.
What are you thinking when you're hearing all these things?
I was disgusted and repulsed. I was shocked and in disbelief.
Did the defendant ever tell you that what he was telling you was just pretend?
No, sir.
When you were sitting there listening to the defendant, was there anything that you thought that indicated he was not telling you the truth?
No, sir.
So initially you were skeptical.
I was initially.
Were you skeptical after you heard it all?
No, sir, I was not.
Did you record the defendant a second time?
Yes, sir, I did.
Is it a similar procedure to the first time?
Yes, sir, it was.
Did the defendant know you were wired the second time?
Yes, sir.
Now, did you ever tell the detectives or the prosecutor that the defendant knew that he was being recorded?
No, sir, I did not.
And should you have told us that from the beginning?
Yes, sir, in hindsight, I realized I should have.
Did anyone ask you?
No, sir, no one asked.
It was kind of like a don't ask, don't tell thing?
Yes, sir.
Have you had the opportunity to listen to the recording?
Yes, sir.
And have you put your initials on the two recordings that you made?
Yes, sir, I have.
What initials did you put?
S-O-E.
Did you print them?
Yes, sir, I did.
May I approach you?
You may. Yes, sir. Just if you have any questions, make sure you maintain distance.
Mr. Evans, have you had the opportunity to look at the two discs that the state just handed you?
Yes, sir, I have.
I'm going to put on the record what those two discs are. 1 second. It's going to be States 5H marked as States Exhibit 112 and States 5I marked as States Exhibit 113. Do those two items have your initials written on that disc?
Yes, sir, they do.
Do those discs fairly and accurately represent the recording that you had with the defendant in this case?
Yes, sir.
I'm showing you what's been entered into evidence as States Exhibit 102. Mr. Evans, do you see that?
Yes, sir, I do.
Is that the diagram that you drew based on the information provided to you by the defendant in this case?
Yes, sir, it is.
Is that your signature at the bottom?
Yes, sir, it is.
Is that the date 2/5/16?
Yes, sir, it is.
Can you describe for the jury the top right corner, what you're trying to convey about where the body parts were?
I was trying to convey the exact distance it would be from the three separate sites.
Are there 4 X's on that map?
Yes, sir, it is.
Would you please, I guess, show where they are? You could use an X or a bigger X. You can use your finger, Mr. Evans, on the screen and it'll show up. Good. Now, before you drew this map, had you ever been to 3551 Bowden Circle East?
No, sir, I haven't.
Before you met Mr. Tillis in jail, had you ever talked to him or met him before?
No, sir.
Well, that's all the questions I have.
Okay. Cross-examination, Mr. Fletcher.
I approach the witness to retrieve the evidence.
Yes, sir. Yeah, go ahead and take the map off. Yes, sir.
Yes, sir.
You're looking at mandatory life, right?
Yes, sir.
You're gonna die in prison, right?
Yes, sir.
Do anything not to have that happen, right?
Yes, sir.
Prison's not fun?
No, sir, it's not.
It's miserable, right?
Yes, sir.
You might want to get the death penalty instead, right?
No, sir, I would not.
Do not. He complained to you about his case, right? Before the homicide, before y'all even talk about anything.
You mean the original case that he had when he came to jail? Yes, sir.
He was in the same courtroom that you were in, right?
Yes, sir.
You were being prosecuted in a courtroom that was presided over by Judge Gorilla.
Yes, sir.
You were being prosecuted in a courtroom that was presided over by Judge Gorilla, right?
Yes, sir.
Y'all talked about it, right?
Yes, sir.
You complained about your lawyers, right?
No, sir, I've never complained about my attorney. I have a great counsel.
You told him you wanted help with motions that you were going to file on your own, right?
No, sir, I was actually helping my counsel prepare a defense for me, and I've done the motion. I just wanted him to write it in a more professional scribe.
I had a lawyer, but you wanted to sort of be legal and assist your lawyer, right?
Yes, sir, I want to be proactive in my case.
You sought out his help to do that, right?
No, sir, I didn't need his help in being proactive just to transcribe the motion. The motion is my motion. I put in all the grounds to this motion. I just had him simply copy it. That's all he did. I have a copy of the motion that he handwritten, but it's my motion. I have the original, then I have the one he transcribed.
Testified on direct that you knew he was good with motions and
Yes, sir. I knew he was good with motions and legal work, but the motion itself is my motion. He didn't add anything to it or take anything from it. I just needed transcribed. That's it.
that's what got you two talking, right?
Yes, sir.
Friends in the jail.
Acquaintances. He would bounce some things off of me, and you know, if I can answer it, I would. But other than that, that's the only thing we had in common.
You had no problem walking up in the cell and saying, hey man, what's going on, right?
No, sir. He would come visit me. I don't go to other cells. I'm normally busy, sir. Not actually wait. I'll go about my day, and if he happened to come, I would put on a book I was reading or put the Bible to the side and see if, you know, what he needed or what he wanted.
Eventually you got talking. Tell us about a different case, right?
When he approached me? Oh, yes, sir.
So you basically said, hey, how would you like to cooperate in the homicide?
He asked me a couple questions before that, but basically that's what he was leading up to.
So he knew, once he started talking to you about this, that you were going to go to the police, right?
I don't know if he knew I was gonna accept the offer or decline it.
Eventually, he knew you were going to.
Oh, yes, sir.
So it was sort of his idea to use you information to them, right?
Yes, sir.
That's what he did, right?
Yes, sir.
But you wrote a letter to your investigator.
Yes, sir.
They contacted the police.
Yes, sir.
The police came and pulled you out of the jail and talked to you.
Yes, sir.
Eventually, they agreed to put a wire on you, right?
Yes, sir.
And told Mr. Tillis you were wired, right?
Yes, sir, I did.
And tell us you this story.
Yes, sir.
And all of this is going to help you, right?
Help me do what?
Help you get a lesser sentence.
I don't know if it was going to help me get a lesser sentence or not because I continued to fight my case for an additional year after I provided the police with the recording device. I've pled guilty now. That was 2017.
How come you haven't been sentenced?
My case is pending connected to Mr. Tillis's case.
When his case finally comes to an end, then it'll be your turn to ask.
It will be my turn to get sentenced, yes, sir.
At that sentencing, you can ask Mr. Mizrahi come in and say good things on your behalf.
I don't know if that's how it goes. I don't know if you can actually request that or not. I just know that I get sentenced.
You're certainly going to call the attention of the court if you cooperated in a homicide case, right?
I don't know as far as the sentencing phase if that's procedure or not.
Cooperating, so mandatory life sentence while in prison gets reduced to something below that, right?
Yes, sir. The Honorable Judge Borello.
So you're going to let him know that you cooperated in a homicide case, right? You're not just going to let that be.
Oh, Mr. Fletcher, that's not a secret. I mean, he's already aware. Everyone's aware.
Was everyone aware that you told everybody aware of that?
I wasn't asked, Mr. Fletcher. No, sir.
You think when the detective put a wire on you, he didn't tell anybody?
It's possible that he assumed that. Yes, sir. Yes, sir, it would. I don't think kill, but possibly attacked or something. Yes, sir, possibly.
All right, fair enough. Let's talk about what he talked to you about.
Oh, yes, sir, somewhat. I heard a small clip just to identify it here recently. Maybe a week ago.
Remember, and you know that there were two recorded conversations, right?
Yes, sir.
One on the 5th of February 2016 and one on September.
Yes, sir.
Have conversations with Mr. Tillis between those two reports.
Yes, sir.
Did the police, after the first one, tell you, hey, we need more details? Try to find out how she was killed. Find out from Tillis how she was killed.
Yes, sir. Something, I guess.
In the second recording, that's what you're asking. You keep getting around.
Yes, sir. I don't know if I don't think so. I don't remember if he said how she was killed or not. Yes, sir.
Also, let me ask you, you told Mr. Mizrahi that as he was telling you all these things, you believed all of it, right?
Yes, sir.
It made sense, right?
It was extremely elaborate, and I just didn't think he was making it up.
Ask you this. He said you bring girls in, you shackle them to the floor, and sell them to guys who were coming by for sex, right?
Yes, sir.
Right?
Yes, sir.
He told you about Jimmy, and he told you about David, how they did all the time, right?
Yes, sir.
This one, that one, all that stuff, right?
Yes, sir.
He told you one of them that he was having sex with, he fell in love with it, right?
Yes, sir.
And she became his girlfriend, right?
Yes, sir.
She started cooking and cleaning for him, right?
I don't remember all of this, but I mean, if it's on the CD, I guess. I just remember some of it, though. When you go into the relationship and fall in love, I don't remember that.
Oh, you know, you overpower her, you lock her in a room, and eventually they come around to understanding things.
I think so.
That's how it is. Kidnap a girl from out in the world, shackle her in a room, rape her, sell her to your friends, eventually,
I know it's a such thing as breaking a person, and I remember a similar case in California where the guy, in jail, people's spirits get broke all the time. Like they just become docile and they don't fight their case. They become complacent. Sometimes you ask them, how come, you don't go to the law library, and they be like, hey, I've just given up, No, sir. No, sir, I don't.
just so I'm clear though, actually held up a sign each time that says, I'm wise.
I just remember the first time. Yes, sir, you knew.
Okay. Anything else for the witness? All right. Thank you, sir. You're free to go for now, but subject to recall.
Yes, sir.
Members of the jury, let's take a brief recess. We're not ready for our lunch recess yet, but let's take a brief comfort break. Remember, during this break, hold on. Do you want to take a lunch break now?
Yes, Your Honor. We will a little faster.
All right. All right. Well, then we're going to take our lunch break now. Okay. During this lunch break, you do not need to stay together, but whether you're together or apart, do not discuss the case. Don't allow anyone to discuss it in your presence. Don't look up anything about the case. Don't visit any of the places described. Report back to me if anybody tries to talk to you. I'm not suggesting that that will occur, but if it does, you know what to do. And let's come back at 12:45. It gives you about an hour and 15 minutes. So 12:45. Thank you. Yes, sir. I may hold you to that, but go ahead.
representation. And there is also an issue of the suppression motion that was filed and denied by Your Honor, and I wanted that issue preserved for the direct appeal, but I don't see that Mr. Fletcher is going to object to any of the recordings being introduced by the state or the state using the transcripts from those recordings. And I would like to place into the record that I am objecting to any transcripts being used regarding that recorded conversation, and I would like to preserve the right to have that issue preserved or to addressed on direct appeal. The third is a pro se objection to appointed counsel Donald Mayers representing the defendant at trial. The defendant refers to the written objection placed on the record on March the 15th that encompasses previous complaints written about Mr. Mayers' representation. The fourth matter, the defendant objects to Judge Mark Barillo presiding over the trial. And the defendant refers to the written objection placed on the record on March the 15th, 2021, and also includes the two motions to disqualify. And the defendant is extremely concerned that when I testify, I'm going to be describing Your Honor who is sitting on the bench beside me. And I feel that that will prejudice me in front of this jury when I start talking about Your Honor's previous behavior that is cited in the January 29th writ habeas corpus that's posted on court. Some of that behavior from Your Honor is rather disturbing. And I feel like when I'm describing your behavior, and of course you have more statute than I do, more credibility, that prejudiced me when that court is looking at me and then looking at you when I'm talking about you. So the objection is that I feel Your Honor shouldn't be presiding over the trial. And the last objection, the fifth objection, is the pro se objection to the revocation of self-representation in current counsel not using the defendant's defense during trial. The defendant refers to the written objection placed on the record March the 11th, 2021. Excuse me. This objection is connected to the objection to Mr. Fletcher not representing me. It's connected to the earlier oral Nelson petition this morning that Mr. Fletcher is not using my defense. With the deprivation of my self-representation, the court has essentially deprived me of presenting a competent defense to this jury that would include Christy Nigloskry, the woman who has the lips. That is going to be such damaging material to me because I have nothing to prove that I didn't introduce Joni Gunter to Ms. Bryant. Witness Christy, she has the lips. I want her in this courtroom on that stand telling the jury, I have the lips, as you can see, and I am the one that met Ms. Bryant. She has a very clear memory. When I am denied that witness, that's going to send me to death row, Your Honor. So those are my 5 objections. My defense is not being used, and I vehemently object. Thank you for allowing me to put those objections on the record, Your Honor.
Thank you, Mr. Tillis.
Yes, sir.
And Mr. Fletcher, I think the only thing I need to ask you about, I was making notes, I believe we've dealt with all of these issues, however, and I think we dealt with the issue I'm about to ask you about, but I just want to make sure the record is clear. What is the defense, meaning Mr. Fletcher, what is your position on the witness, Christie? Has the defense attempted to locate the witness, and is your position that her testimony would not be helpful to the defense?
Your Honor, I'm just going to interject. We can give the court more information about that, but I think at that point.
You think that should be in camera?
Yes, I think it's just of a nature that.
All right, then I think what we'll do, Mr. Mizrahi, I'm going to, well, I think for this purpose, in camera, ordinarily we would retire to it. Well, we can actually go to the adjoining actual real jury room, not the normal jury room, not the jury room that we're utilizing for this trial, with just defense counsel and Madam Court reporter. Is that what you would be requesting? I don't,
Yes, sir.
do
Yes.
we need the defendant there for that? I think we do.
I believe so, Judge.
Well, I think then the easiest thing to do is we're gonna clear the courtroom. That'll be a closed proceeding. I'll note it for the record, but it's an in-camera proceeding, so rather than, during the pandemic here, rather than us locate to another room, we'll stay here and just get everybody else out of the room. Is that stay good?
We're good.
Okay, so we're going to be in recess until 12:45 for purposes of trial. However, we will conduct the in-camera proceeding right now, utilizing the procedure that I just indicated. So we'll clear the courtroom of all non-essential personnel, including the state and media, family members, any spectators. It'll just be